Good question. I've never met Mrs. Smith. If I have, I apologize, I don't remember. I've been in Port Angeles 42 years. I don't think I know Mrs. Smith. Mrs. Kidd, I probably have said hello to her 3 times in the last 5 years. I know she went to Port Angeles High School. I spent my entire career there. I'd say on a scale of 0 to 10, my relationship with Mrs. Kidd is a 0.1. So I would say, in the answer to the question, no. Completely devoid of a relationship with both ladies.
No, I do not know her. And that brings to mind that this is a quasi-judicial proceeding, which means that we will be determining the facts of the complaint and determining the outcome based upon those facts and the law that applies. And under the laws of the state of Washington, this hearing and everything we do must be fair, and it must have the appearance of fairness. And so your question went to that point, I believe, whether we know anyone involved, and that would go to the issue of an appearance of fairness. And in most proceedings such as this, there are some similar inquiries to yours that we should all answer. And I have taken a page out of another city council's procedure that deals with this, and I would like to read through the questions and then we can all deal with them so that we get started on the right foot. Is that okay?
That's fine. I'll answer.
Okay.
I do not know Mrs. Smith other than Facebook once in a while seeing articles. I do know Cherie Kidd. This is a small town. I went to Port Angeles High School. She was a year ahead of me, I think, in high school. Her father and mother, and my father and mother were good friends. Socially, no. The only thing that we do socially is Seroptimus. She belongs to the new club Seroptimus. I belong to Jet Set, so we don't literally really socialize. But I do know her. I've known her all my life.
Directed to your specific question, I do not know Mrs. Smith. I know Ms. Kidd very, very briefly. I know who she is. I say hi. That's about all the relationship I have with her. I think that my son-in-law and I did business with her company or whatever business form it is when we rented a truck one time. And that's the extent of it. I'd like to go through the rest of the questions, if you don't mind, and they'll be directed to all of us. And this is necessary, as I mentioned, to ensure that this hearing is fair in both fact and appearance. Does anyone have any objection, specifically the parties? I know Ms. Kidd is here. Is Mrs. Smith here? Oh, okay. Do either of you have any objection to Mr. Prince serving as chair?
No.
And let's see, does anyone have any objection to any member of this panel?
I'd just like to ask, I don't know if it's pertinent or not, but where you guys each independently stand on the fluoride issue, and how is that going to affect, or should it affect, the outcome of this?
I'm sorry, but thank you.
Yeah.
Is this procedure today, Mr. Bloor, is this a question and answer session?
No, it's not. This is a more like a, sorry.
That's all right, it's not you, it's me.
This is more like an organizational meeting. We're going to determine how we want to proceed with the meeting. I think it is a good idea that you go through the same questions that the city council would use for appearance fairness doctrine. Apart from that, you're not required to do or say anymore. But again, it's up to you on how you approach this.
Okay, thank you. I anticipated that question. Okay, I really did. Let me respond this way. The word fluoride is irrelevant, in my opinion, to the three of us. The city council meeting that is in question here could have been about any subject: homelessness, crime, taxes. I don't expect the word fluoride to ever come up again. I think our panel has been impaneled and empowered to review the actions of the city council members. What the meeting was about is irrelevant to the three of us, and I believe it's irrelevant completely to these proceedings. If I'm wrong, I want Mr. Bloor to say, "Oh, Frank, you made a mistake." I think we're here to look at the actions of the council members in regards to the city code, the municipal code, the state law. What the meeting was about has no bearing, okay? And that would be my response. If I'm wrong, I'd like someone to say, "Stop, Frank, you're going the wrong avenue."
No, that is the correct attitude that we would like the board to adopt. Thank you.
Thank you.
Mr. Chair, may I respond?
Oh, knockout.
To the question specifically, I was aware that there was a question regarding fluoride. I remember receiving a survey in the mail, I believe, and my wife and I looked at it, and we did not complete it, as to my recollection, and we did not turn it in. I have no opinion one way or the other on the fluoride issue.
Judge Minor, would you register an opinion on this? A lot of the proceedings that brought us here today are the result of city council meeting. A lot of those city council meetings are guided by the legal advice of Mr. Bloor. Mr. Bloor is a victim or a target of another ethics complaint. We're talking about the appearance of fairness and lack of bias. Should he be the one advising you on this if he's also himself under an ethics complaint?
Oh, please, I have a response, but it'll be the same, I bet.
Would you please identify yourself, sir?
Yes. I'm Leo Wilson. I'm a publisher of the Protocol Monthly News Magazine.
Good morning. I don't know the answer to that. I think that's up to Mr. Bloor and whether he conceives that he has a conflict. If so, he should recuse himself and another attorney would be appointed, I would think. And I'm going to leave that up to Mr. Bloor. Does anybody else have anything to say?
I'm first going to qualify Mr. Prince's statement, and I am in complete agreement with him that this is an issue involving a complaint. It is not an issue involving fluoride. And opinions on fluoride I don't think have any relevance whatsoever in this room. We're here because of a complaint, and that's why we serve on the Ethics Committee. Mr. Bloor, I don't know if you want to use the word advise us. I think he's a guide, but in agreement with Judge Minor, if he chooses to step down because he feels it's a conflict of interest, then we hold up proceedings because we're going to have to wait for another attorney to be appointed. I look at him as a guide. I don't look at him, sorry, Mr. Bloor, as someone who's telling us what to do. He's here to guide through the process. And I think the three of us are capable and competent enough to know the difference between a guide and somebody telling us what to do.
May I proceed with the question?
I was going to ask you to do so. Miss. Yes, ma'am. Hello.
Yeah, I just have one concern. I'm Deborah Wilson. I'm born and raised here.
Hi.
Hi. Nice to see you, Mr. Johnson. I'm not familiar with the lady on it, and I can't quite read her name because the glare is on the thing. But I'm a little concerned that she's known Cheryl Kidd, like all of us in the families have kind of known her for such a long time. How can you truly be biased? Can you say something to that?
The families knew each other when we were young. I mean, young. 5, 6, 7 years old. This kid left Port Angeles for many years. I left Port Angeles for many years. In fact, I think she came back after I did, but I would say probably since 1965, we have never socialized other than at a seroptimus function. I know her because small town, lived here all my life, except for 10 years that I've gone. So socially, no, other than seroptimus is all we've ever socialized.
Thank you.
Judge Minor, you're up.
Thank you. The next question to us is, well, I'm sorry, do either of the parties have any objection to any of the board members serving? I may have asked that. If I did, I apologize.
I don't have a problem with that as much as I think that was a good point that he made about Fleur being also having a complaint against him.
Oh, thank you.
I want to make sure that I made that point.
Thank you.
Yeah.
Mrs. Smith, did you understand the question?
Yes, I did, and
All right.
I have no complaints.
Thank you. And do any of us have a conflict of interest to disclose? I do not.
None whatsoever.
None?
Do any of you have any private information about the subject of this complaint? I do not.
None whatsoever.
None whatsoever.
Has anyone received any ex parte, that means outside of this room, communications about this complaint or matter? I have one. In just a moment I'll review.
The communications I've received, people are fascinated that I would actually volunteer. They're running for the hills saying I would never do this. I look at them, I'm saying it's my responsibility, my obligation, I volunteered, and I'm proud to do it. But all my friends think I'm nuts. But they're right.
In a good way.
But they do, and I think that's a fair question. Matter of fact, just the other day at the gym, one of my very closest friends said to me, "Why are you doing this? You're crazy. I would never do that." I looked at that person and I said, we all have responsibility to do this, whether it's pleasant or unpleasant. And I truly feel that way, and I want to make my commitment to all of you that are seated here and those who are not, that I, Frank Prince Jr., will give you the most honest effort possible. I know Grant and Danetta will also, but that's a fair question.
Communication regarding the complaint, no. But clarity from the public when you, and I think we made this clear tonight because a lot of the public feel this is an issue that has to do with fluoride. Don't look at it as an issue, as a complaint. So there's been a couple of times I've had to clarify that this is not to do with fluoride. As far as the complaint, no, I've had no communication.
I said that I had one matter to reveal, and this is something that I do in an abundance of caution because I don't think that it was, well, I know it was not a communication, and I doubt that it was an effort to communicate. However, I have an adult daughter who is active in the community. I think that she is acquainted with the complainant, Mrs. Smith, or Ms. Smith, and it was the day that my name was revealed as being selected to be on this board that Ms. Smith contacted my daughter by email and suggested that they have coffee together. And from what my daughter has told me, she has not had that kind of a relationship with Ms. Smith before. And I did not, and I don't believe she had the meeting with Ms. Smith, and I don't make any more of it than that. And like I said, I report it out of an abundance of caution and it will not affect the way that I decide this matter. And I see Mrs. Smith has her hand up. You don't need to say anything. If you wish, you may, of course.
It had nothing to do with this at all. It was completely an independent thing regarding a July 4th celebration that I'm trying to come up with, and I was meeting with her because it was suggested that I should meet with her, but it had nothing to do with this.
Okay, thank you. All right.
May I suggest, Mr. Glover and Judge, would you take a moment, and I know you have an agenda here that you would like all of us, the three of us especially, to hear to be efficient and professional. May I ask that you plow right through that, and then we'll go to step number 2. Is that acceptable?
All right.
Thank you.
I only have one more question. Can all of us decide this matter in a fair and impartial manner based upon the record in this proceeding? I can.
Undoubtedly, honestly, and with 100% confidence.
I certainly can.
That concludes those questions. Thank you.
Thank you. Okay. I can assure you the president is not nominating me for the Supreme Court. I want you to know that. And you can tell by the way I'm grab bagging this, all right? Please. The Senate would never approve me. In front of us, with your permission, Grant and Danetta, I would like to read for the three of us. I guess the best way to proceed is for the three of us in a public forum to take the complaint and go through it, publicly discuss it, and see where we stand before. My impression, if I'm wrong, please stop me. We're not making a decision at this moment. My mind is blank, absolutely blank in this regard. I would like to build up, with your permission and your permission, information to help us make a decision. I have an absolute blank slate in regards to this complaint.
I don't have any specific objection to that, Frank. We have the agenda here in front of us, and the initial review section, section D, sets out two general areas to inquire. And the first, being a lawyer, I would look at as a decision that we have to make as a matter of law. We have to determine what the complaint does and does not say. Secondly, we have to determine whether, if the facts alleged in the complaint are true, does that then amount to a violation of the Code of Ethics? And that is a question of law. And I'll ask our legal advisor if you would basically agree with what I've said.
Yes, and the language from that section is taken directly out of the ordinance. So what is set out in section D, where it says initial review, that is directly from the ordinance, and the ordinance itself provides that you go through that initial determination.
If I may continue, Mr. Chairman.
Please.
I have reviewed the complaint, of course, and I have reviewed the ordinance, the City Code Ethical Ordinance. And that ordinance uses words that are referred to in the complaint, are used in the complaint as well. And it's my belief that we should look at those words and determine what they mean. And I think that in an effort to do that, I would ask for the assistance of the parties as to what those words mean, and I would look to our legal counsel for any advice as well. Specific words, and I'm not going to go through them all, but at least a couple of the words that are used in both the code and the complaint are such as these: harass or harassment, immediate, I believe is used, respect, and other various words. And I think that we have to know what those words mean in the context of this proceeding, and we have to decide whether or not the facts that are alleged, or how the facts alleged deal with those words. And that's the essence of my concern in this matter. Frank, if you haven't seen it, there's a hand up.
Be with you in just a moment.
Okay.
I promise you're next.
All right.
Citizens and Mr. Bloor, I will tell you my greatest fear, my greatest anxiety is the following. I really do not want the three of us to get into a she said situation. I was not at the meeting that is the places of the complaint. Neither was Judge Minor, neither was Mrs. Rutten. I don't know if it benefits anyone if we get the two complainants, Mrs. Kidd on one side of the council chambers, Mrs. Smith on the other side of the council chambers, cross-examining each other to an extent. Judge Minor used the word evidence. I understand, that's what I'm looking, Not having been there, if we have questions about what actually transpired at this city council meeting, are you our reference or are the complainants the reference?
Video.
Well, yeah, if you want to know what happened at the council meeting, the easiest way is if you want to know what happened at the council meeting, I think the easiest way we'll use to obtain that is through the audio recording of the council or the video recording of the council meeting. So you can watch the entire meeting from beginning to end if you wish to do that.
It's public.
Right, I am aware of that, and I thank you for your response. I haven't forgotten you. Back to Mr. Bloor. We sit in somewhat quasi-judgment of the actions of Mrs. Kidd. Correct or incorrect?
Your role is to look at the complaint, determine whether the complaint alleges a violation of the ethics code. If it does allege a violation of the ethics code, then the next step is for you to do some investigation to determine what actually happened, and then to use your independent judgment to determine whether the actual happenings do in fact constitute a violation of the city's ethics code. I'm not sure that helped, but...
Well, no, it did.
Okay.
We can't get to step B until we decide step A.
That's correct.
Yes, ma'am.
Yeah, I'm Deborah Wilson still, and I have not, yeah, I still am. I would like the complaint read, because I have not heard it read, maybe leading up to this, because, you have different things you gotta get done. But I'd like to hear what was written from, top to bottom.
With your permission, I was going to ask Judge Minor, it's about, I think there were 6 points. Okay, am I correct? No, there's 8, I'm sorry. We would look at each one individually. Okay, and that was something I was going to suggest. Thank you for your comment.
Mr. Prince, I can always make copies of the complaint available to the public if the board doesn't wish to go through the time of reading it all. I can always make copies available to you.
To be efficient, and I'm sorry, this is not my strength. To be efficient, though, Mr. Bloor, and I think Judge Minor already understands this part. Question A has to be decided first. And would you, in layman's terms, from myself and maybe from Mrs. Rutten, question A that the three of us will determine is what?
The city ordinance sets out a two-step process. The first step is to determine whether the complaint actually alleges a violation of the city code. So to do that, we must look at the complaint itself, read the complaint, compare that to the specific provisions of the ordinance, and determine whether the complaint actually alleges a complaint of the ethics ordinance or something else.
Understood.
No.
Great. Excellent. Thank you, Mr. Bloor. Thank you. I'm going to make another suggestion. Judge Minor, what I would like to do, stop me anytime, I would like to read each of the 8 points one at a time, okay? And you then will let Mrs. Rutten and I know, does it meet the threshold of what Mr. Bloor just said? Or is that completely confusing?
Well, I don't want to get bogged down in semantics, but if I may expand on what Mr. Bloor said, we are to determine, first step, whether or if the facts stated in the complaint are presumed to be true, whether that would be a violation of the code. We must assume that the facts alleged are true, and taking the facts in that light, does that amount to a violation of the code? That is a question of law. We don't need any evidence for that. We need to know what the words of the ordinance mean, and we need to know what the words, we need to know what the words of the ordinance mean, and if the things that are alleged fall under those words, then we proceed to step 2 and find out actually what the facts are. Stop me if I'm wrong, Mr. Bloor, but that's the way I see it.
No,
so,
that's correct.
Our first task is to read the complaint, determine what the words mean, presume that what is alleged in the complaint is true, and decide whether, in that light, that violates the code. And so I go back to what I said before. We need to know what the words in the ordinance mean. Generally, in the review of legislation, a court will look at the common and ordinary usage given to words. Is that what the City Council meant when they adopted this ordinance? Did they mean the dictionary definition? Are there court cases that deal with a similar situation where the court went to the what we're dealing with here and determined what words meant in a specific situation? If so, I would like to know what those court decisions are, because they may help us in determining what the words of this ordinance mean. I'd also like to know what the dictionary definitions of those words are. And then if there's any evidence, which I would be surprised if there's any evidence that can be presented on what the city council specifically meant by specific words, I'd like to know that too. And on the point of court decisions, I don't remember where I got this impression. Perhaps it was from an article I read in the newspaper, but it seems to me that I heard or read that Mrs. Smith had cited court case or court cases on that point. Do you wish to respond, Ms. Smith? Do you have any cases?
Not off the top of my head. Just go with what you're going with, because the problem is the way that the law was written by the city council. I found it to be a little muddy. So it's open to interpretation still. So I like the exercise you're going through. That's excellent.
And Ms. Kidd, do you have anything on this?
Well, it's just a little curious that if you assume that the complaint is true, the complainant is from an opinion of someone, and we all have different opinions. So,
No, the question, the bottom line, is that we're looking to determine whether or not, if the facts that are alleged in the complaint are true, and we will presume that they are for this exercise, if we presume the facts are true, do those facts allege a violation of the code? And that's why words are so important. And I think that we need assistance to guide us. We need court cases, we need dictionary definitions. I'm sorry to belabor this, but I think that's a very important threshold that we must meet. If the facts that we presume to be true do not allege a violation of the code, the complaint will be dismissed. If we find that the facts that we presume are true do violate the code, then we proceed to a hearing, a factual hearing, to determine what the facts are. And we determine what the facts are. Mrs. Smith has a question.
The only code that I cited was either the city code or the Open Meetings Act from the state. I didn't cite any court law because I don't have access to LexisNexis. And I couldn't find any similar wording by doing some deep Google searches or to find law. So we are where we are.
Well, Mr. Chairman, it's my opinion that we need some guidance here. And if this were a court case, I'd be looking to the parties to proceed to provide that guidance. I'd be looking for a brief. But we are not that formal, I know. But I need some help. What do these words mean? What did the city council intend? Is there any way to determine that? Is the dictionary good enough? Have courts interpreted these words before in this situation? And how have they interpreted them?
Three of the sitting city council members were helped design these laws, as did Mr. Bloor. So we have some people in the room that could probably answer some of those questions.
Perhaps.
Brian? Can I speak? Do you want the definition of harass?
No, I'm sorry. I apologize. Excuse me, I'm sorry. I was just formulating my thoughts. My apologies. in regards to legal definitions, I would propose that the three of us, I guess it comes down that the three of us will have to make certain decisions today or whenever this process ends. I would propose that the three of us defer on all legal definitions to Mr. Bloor, who is the city attorney for the city of Port Angeles. I don't know if it benefits anyone having anyone but the city attorney guide us on legal definitions. We have a judge right here. Between the two of them, I think that is the efficient and the proper way to go. If that's wrong, the two people who will tell me I'm wrong are on my left and my right. And I'm proposing to Mrs. Rutten and to Judge Minor that we defer to Mr. Bloor for our legal definitions.
Well, if I may jump in here.
I'm sorry?
If I may.
Of course you may.
I think that Mr. Minor was going down the correct path of determining how you interpret words in an ordinance. First of all, it doesn't matter really what I think about them one way or another. There is a standard way that you interpret laws and other legal documents. It's pretty well set out by the courts. First of all, you look to see if the ordinance itself provides any definitions. And in this case, it does not. At least one of the words that I heard to be in question. I think one of them was harassment, another one was respect, and I think there was a third one, I'm not sure about that. But the ordinance itself does not provide definitions. So, not providing definitions, then there are some other ways that the courts approve us looking for the meaning of words. One is that you just go to the dictionary. Where there is no definition, then the courts defer to the common dictionary definition. And I can certainly go to a dictionary and get definitions of each word. The other thing that courts look at is whether another court has made a interpretation of the words in a similar context. I do not know the answer to that, but again, I can learn that. I can provide that information to you if there is any. But my role, I think, is providing information to you, and you're the ones that ultimately are going to have to apply that information.
Yes, and this lady here,
Yes.
thank you. Good morning.
I just wanted to bring up, I don't know how you guys are going to do this. It's a big task. It has to come down with words and also actions. What actually occurred at the meeting, and how are you guys going to determine that unless you watch the video?
That's right.
And listen to it.
That's right.
I have to say that.
No, I appreciate that, and I believe I mentioned that already. You know.
Yeah.
You're next, ma'am. That's a promise.
Yeah. I'm Deborah Wilson.
Still Deborah Wilson. You haven't changed.
No,
You're going to be Deborah Wilson all day, I bet.
You're darn right I am.
You're up, Deborah.
Yeah, I just want to say I agree with, I'm looking at the legal definitions stuff, definitions of words, but I also agree with Leanne that it should be seen, because you can say, it's all about your inflection of your voice and your body language and all of that. It's like you can say, oh, I like your shirt. Or you could say, oh, I like your shirt. You know, you can say it sarcastically, you can say it kindly. And so you might know a definition of a word, but the way a person uses it, I think makes a big difference. A lot of us have been totally just condescended to, and we're irritated and angry about it. And we do believe that there's a problem. That is very unprofessional and insulting.
Understood. Understood. In deference and respect to your comment, though, I believe the three of us, Mr. Bloor will stop me again if I'm wrong, the three of us collectively will establish the path that we're going to follow. Audio, it may not. I mean, I believe we have the leeway to say the three of us are going to link arms, and in fairness, this is the path we're taking. Obviously, we're taking in all this right now and trying to assimilate it and collate it and come up with what we feel is not only fair for Mrs. Kidd and Mrs. Smith, but more importantly, the entire city of Port Angeles. And that's not a responsibility I take lightly. If I'm being redundant in my comments, it's only because I want to make sure I dot every T and cross every I. So please bear with me, okay?
Yeah, I just wanted to make that point. I think it's a very, very, very strong point, and I want to urge all three of you to actually listen to the tape and look at the video.
Thank you.
Thank you.
You're most welcome. I commend you for your involvement. Final comment from this gentleman, then I have a proposal. Yes, sir, good morning.
Good morning, Robert Flood.
Hello, Robert.
How are you?
Well.
Mr. Minor, I enjoy your conversation here on the definition of the words. I think it's very important. I don't know if this is a good suggestion or not. However, Black's Law Dictionary is a pretty good dictionary to get the definitions of words. I don't know, I know the word LexisNexis, I know that you can go in and get just about any case you ever wanted information on. Perhaps there's a way through LexisNexis that there's, if you put together a list of words that the definitions can be found. If it's not something that was decided by the U.S. Supreme Court or the Washington State Supreme Court, then you would defer to Black's or Webster's or whatever general dictionary that you chose to use. Just a suggestion.
Thank you, sir. Thank you again.
I have a question for Mr. Bloor, if I may.
Oh, you're up, Judge.
Mr. Bloor, the code says that we may deliberate not in public. And would that include a deliberation upon the complaint and a conversation among us to determine what the words mean?
I believe it does. However, as used in that context, deliberation does not mean decision. It only means discussion. So any decision that you make must be made in public, and you must explain the reasons for your decision in public. So the deliberation is the preliminary part, but the actual decision making has to be in public.
Thank you, Mr. Bloor. That was, you'll be next, sir, I promise. I'll speak generally, but I'm actually speaking to Danetta and Grant. When the city council chose me, and I was privileged to be chosen to be on this little panel, I deliberately divorced myself from all information in regards to this complaint. I did not read the complaint ahead of time. I did not read really anything in the newspaper about it. I decided that I thought it would be best for me to arrive this morning with Danetta and Grant completely devoid of a preconceived notion. I did that because I was the foreman of a jury several years ago of a criminal case of an ex-student. I cannot believe they put me on the jury, but they did. I cannot believe they made me the chairman, but they did. And she was my ex-student. But I took that responsibility seriously, and I devoided my mind of everything I could possibly devoid it of in regards to that ex-student. And I took that responsibility seriously, and being that jury foreman was the event of a lifetime. And I say that proudly. Reason I bring that up is I want folks to know from my perspective, what I have here in front of me is the first time I've been exposed to it. I thought that would be the fair thing to do in regards to Mrs. Kidd, to Mrs. Smith, and to the city. So if it sounds like, geez, Frank, you didn't do your homework, that was by design. That was by design. I thought it was like a court of law. Danetta, and Grant would only decide on what we see starting at 10:30 this morning, nothing prior to 10:30. If you feel that was an error on my part, Mr. Bloor, I'm a big boy, I can listen.
No, that is certainly the most cautious way to approach this. This hearing is subject to the appearance of fairness doctrine. And it does require that the three of you not have any ex parte communication with anyone about this. And it also requires you to have the appearance of fairness as well as actually, in fact, being fair. And so certainly the approach you have taken on it, no one can quibble with that.
Thank you, Mr. Bloor. Yes, sir. Good morning.
Good morning. Jim Bourget is my name.
Hi, Jim.
Causing trouble is my game. No. Anyway, would Robert's rules have any impact on what is required as the performance of the city council members, and any impact on whether or not things were deemed to be unethical or inappropriate or whatever? I guess that's a question for both Attorney Bloor and the panel.
Judge Minor first, please. I'd rather, with everyone's permission, to direct those to my colleague here. This is the man that will refer to.
So, of course, I think that's something to be considered. But I say again, our first decision is to determine, assuming the facts alleged in the complaint are true, our first decision is to determine whether or not the allegations arise to a violation of the code. If they do, we proceed to factual hearing. If they do not, we dismiss the complaint.
I understand that. I'm just curious if that would be, if you do proceed, if that would be part of the equation. Considering Robert's rules. Okay, thank you.
Good afternoon, sir.
Yes, hi. James Preston, I'm a Port Angeles resident. First of all, I want to thank you all for obviously appearing to take this very, very seriously. I do want to thank you for coming here with a clear mind. Most juries don't do that, and I'm an attorney myself in a different jurisdiction. I think what you're struggling with here, it's called a prima facie case. You assume that everything written in the complaint is factually accurate. So every word in the complaint is deemed to be accurate for this purpose. And then you take a look at the law and you say, assuming everything's accurate here, does it violate what's in the law? That's your first step. If it doesn't, then it fails on its face for failing to state a cause of action. So that's what they have to do right now. And Your Honor, I can sympathize with you that you don't have a brief or anything else. So how do you interpret the words? What's been determined before as to what the words mean? You may want to deliberate in private or something on this, but thank you for considering it seriously.
Thank you for your input. It's nice to hear a compliment to my naivete. In the back, and this will be our last comment, so that we can plow ahead.
Bob Lawrence Markarian, also from Port Angeles, and I want to thank you for your slowness and diligence and appearing very transparent. I do appreciate that. It's not something we need to hurry into. A suggested you will probably think of this on your own, but as Judge Minor pointed out, the words are very important. Coming up with a common definition of what constitutes harassment, for example, or any of the other words that are in the allegation, come up with those definitions first before viewing the video so that you have parameters and framework. So when you see and hear things, you can say, that fits with our definition, that doesn't fit with our definition. Just a suggestion.
Thank you, Bob. Final comment to you, sir. My son said to me, my son Frank Prince III, he said, how long is it going to take, Dad? And I'll tell you, I told him, it'll take as long as it takes. I've got nowhere to go, and Judge Minor and Mrs. Rutten feel the same way. If this takes an hour, or if it takes 2 weeks, we don't care. We will do it correctly and fairly. We've made a commitment, and we will follow through on that commitment. Okay? I can assure you of that, sir.
Mr. Chair, may I comment?
Please, Judge.
Thank you for your calling this what it is, prima facie determination. And thank you, sir. And may I comment that, in my opinion, we do not, and we perhaps should not, look at the video or listen to the audio tape until we have made the first decision, which is to review the complaint, assume that the facts are true as alleged, and determine whether that is a violation of the law. We don't need to tape in the video for that. At least that's my opinion.
No,
Mr. Chair.
I agree. Jennifer, that's right?
Yes, sir.
Good morning.
Good morning.
That's a lovely color you're wearing. I like it. May I have a few pieces of... May I have a few pieces of blank paper, please? Oh, the judge has it. The judge has it. Says Superior Court of Washington on it. It's been in his den for years.
Do you need a pen too?
No, mine all say Port Angeles High School on it. Shh. All right. Mrs. Rutten, Judge, with your permission, I would like to read out loud. Now, there's one complaint, 8 parts, or 8 complaints?
One complaint, 8 parts. One complaint, 8 separate parts, they need to be treated
That's
separately.
good, that's good, I'm good.
Yeah.
One complaint, 8 sections.
8 separate sections.
Thank you, sir.
Separately treated.
Okay, Judge Danetta. Step 1. We assume the actions listed below are accurate. If so, if those actions are described as being accurate and having occurred, do they then possibly violate municipal code of the city of Port Angeles? All right? That's what I have gathered from Mr. Bloor and Judge Minor. Item 1. Signs prohibiting posters not allowed in chambers. I read that as being, there was a sign or signs outside the city council chambers prior to a city council meeting saying, do not bring signs into the chamber for the city council meeting. You may come in, don't bring your signs. Is that how you two read it?
Yes.
Yes. Okay. Mr. Bloor, is there a municipal code for the city of Port Angeles prohibiting signs at a city council meeting? Is that in the city code anywhere?
No, it's not in the city code.
It is not in the city code.
No.
Has it been past practice to allow or not allow signs in city council meetings?
Yes, it has been past. Yes, it has been past practice not to allow signs in city council meetings. Let me say also that it is addressed in the city council rules of procedures that the chairman of the meeting has the authority to control and limit the public comment section. So
that's number 2.
Oh, okay. All right.
Right? Yeah. Thank you. Hold that thought. To reiterate for my colleagues, Mrs. Rutten and the judge, signs prohibiting posters not allowed in chambers is number one of the complaint. Excuse me, just...
Okay.
You've had your timeouts in the first half. You'll get some timeouts in the second half, I promise you.
Oh, thank you.
Signs prohibiting posters not allowed in chambers. If there was a sign saying that, the code says what about signs? One more time for everyone's benefit and mine? Or doesn't say? Please?
There is no code.
Okay. There is nothing in city code, in the Port Angeles Municipal Code, that says anything about signs.
So,
in council chambers during the council meeting. But I think what the question is if there was a sign posted, does that violate the provisions of the ethics code?
do you understand that?
If I may ask. So, Mr. Bloor, if I understood what you said, we're dealing here with whether or not the sign posted outside chambers saying no signs allowed inside, whether or not that is a violation of the code, not whether signs are actually brought into chambers.
Yes.
Thank you. Mr. Bloor, who posted the sign, "Don't bring in signs"?
The city clerk did.
That's this lady with the beautiful blue teal. Jennifer, who gave you the sign?
I made the sign.
Under the direction of whom? Is that allowed to ask? I think it is. Shh, folks. Miss Jennifer, you made the sign, thank you. Who told you to make the sign?
If I may, Mr. Chairman. If I may, Mr. Chairman.
You may.
The sign was outside. I think that's established, right? Now we're getting into facts as to why the sign was there, who put it there, why. We don't need that at this point, in my opinion. We need to know whether it was there and did it violate.
No, okay. This is where we're going to have our arm wrestling match. The complaint filed is against Mrs. Kidd, correct, Mr. Bloor?
Yes, certainly that's correct.
Correct. If Jennifer, in her own civic-minded duty, decided to put that there on her own, without any sort of connection to the city council, we have a different argument. If a mayor, the city manager, or city council member directed Miss Jennifer, make the sign, put it up, we have a different ball game.
Thank you.
I'd like to know if Jennifer did it on her own. If she did, great. That tells us that, in my opinion, number one has nothing to do with Mrs. Kidd. She had nothing to do with it. Jennifer thought this was the way to make the meeting run smoothly. Stop me when I'm wrong, please. I don't want to put you on the spot, sweetheart, but I have to ask.
Yeah, I put the sign up under direction. If the board would like me to further comment on that, I can. If you want, if that's all you need to know, then that's fine as well.
Would you like to know who asked Jennifer to, would you like to know who asked Jennifer to create and post a sign?
Of course. But I don't know that we want to know that now.
I do. I tell you why.
Well, we're three, we can vote.
Right? I'll tell you why.
Go, yeah, I'm listening.
If Jennifer did it on her own, out of a civic-minded duty, then I'm ready to cross off number 1, and we're down to 7 items. We have to eventually, Grant, whittle down 4 pages and 8 items that we're gonna arm wrestle over. And I think if we eliminate number 1 right away, because Jennifer just did it. Great. Move on. What's number 2? I think people would respect that. We looked at number 1, she had nothing to do with it. We know that. Great, move on. But if I'm wrong, so don't answer. Would you like to know who asked Jennifer to post and create the sign?
Yes.
I would too. Judge, you're up next.
Of course I would, but not now.
Okay.
It's 2 to 1.
Okay. Who asked you to do it?
The city manager asked me to post a sign.
The city manager, not Mrs. Kidd.
I work under the direction of the city manager.
Okay, so as of today, Mrs. Kidd didn't give you any information about posting that no poster sign.
I would say that Mrs. Kidd and I spoke about it, but I work under the direction of the city manager. So I would not have posted just because Ms. Kidd asked me to. The city manager asked me to, but Ms. Kidd and I did have a discussion.
Thank you, sweetheart. I don't mean to put you on the spot, but you understand what I'm trying to do. Mr. McKean, Dan said, Jennifer, put that sign up.
Yes, sir.
Point
Well
of
done.
order, Mr. Chairman. Point of order.
Go ahead, sir.
Witnesses are to be sworn to tell the truth in this proceeding. And I think that if we're going to take testimony, the witnesses should be sworn.
Yes.
Are you able to swear witnesses, Mr. Gore?
I don't know.
I'm not either. I'm not a notary.
Okay,
We need someone who's able to swear.
I understand that.
Yeah.
I understand that. Excuse me, I'm from New York. We stand, we talk with our hands. Thank you. Hold on, sir. Ladies and gentlemen, please do not interpret my enthusiasm one way or the other. I've made a commitment to all of you and to my colleagues. I'm going to do this right. Okay? I'm going to do this right. Mrs. Smith, I will do you right. Mrs. Kidd, I will do you right. Okay. The complaint in front of us, filed by Mrs. Smith on Mrs. Kidd. According to Jennifer, who was one of our city administrators, the sign that said, "Leave your signs out," was put up by her under direction of Mr. McKean. Correct?
Yes.
That is correct.
I don't think we need sworn testimony. No one's going to jail. Your first comment to us was right on. Mr. Bloor's first comment to us was right on. These are alleged actions. Are they true? Do they violate the code? For Jennifer has told us, and I don't want to put her on the spot, but I think she appreciates my position, our position. Mrs. Kidd did not tell you to put up the no poster sign. Mr. McKean directed you to do it.
Yes, To be fair, Mrs. Kidd and I had a conversation about it. But Mr. McKean is the one who directed me to put up the signs.
Thank you. And please accept my apologies if I have put you on a spot. That is the last thing I wanted to do. I didn't even know I was going to have an audience today. I would have rehearsed. Comment? I have a motion, a suggestion, but after you, sir.
About the swearing of witnesses?
No, about number 1. I'm trying to winnow down 4 pages to several items that you and Danetta and I can really put our teeth into. In my opinion, stop me, Grant, when I'm wrong, Mrs. Kidd cannot be held responsible for something she did not direct. Folks, this is not a basketball game where you yell at me when I make mistakes, okay? I get that all season. Okay, Momentito, man, you will be next, I promise. Are you with me? You're a sweetheart. The complaint filed by Mrs. Smith is filed against Mrs. Kidd. Mr. Bloor, am I wrong or am I right?
You are correct.
Thank you, sir. Number 1, by my own brashness, put Miss Jennifer on the spot. She has told us in public forum that our city manager, Dan McKean, told her to create and post a sign. She had a conversation with Mrs. Kidd, yep. Did Cherie Kidd say, Jennifer, put that sign up? No. Shh. The game's still on, folks. Hang on. Judge, you're up next. I know you don't like my legal precedents here. I understand all that. My point is, I'm willing to take number 1 and move on, because I don't see how Mrs. Kidd had any impact on number 1.
May I?
Go ahead.
May I ask, how much time do we have today?
I had budgeted a meeting from 10:30 to noon.
What an optimist.
With the anticipation that you all would meet again, you can set some parameters of this meeting and then have another meeting sometime in the future.
Hold on. Ma'am, I haven't forgotten you, I promise.
I understand what you're saying, Frank, and I respect that. What occurs to me is, in the second part, if we get there, of this procedure, the factual hearing, is this witness going to be called to testify again? And if so, are we wasting our time now? I'm just concerned that we may not be doing this efficiently.
I agree with that. I am, inefficient is, me in the legal world, synonyms. I'm not arguing that, sir. I wish I had a better handle.
See if Mr. President.
I see that, I saw that. Your second, sir, I promise. Yes, ma'am, I promised you a comment. Go ahead, ma'am.
Well, I don't see how you can dismiss it out of hand when Jennifer clearly stated that there was a conversation with Mrs. Kidd. It depends on the content and the intent of the conversation, doesn't it?
I appreciate that. My response to you, I thank you for your input. I asked her a simple question, though. And we can elaborate. Who told you to put up the sign. Now, that was my question. Am I correct? I just wanted a simple answer. Okay, and she was brave enough to give it to me, and I feel terrible about putting her on that spot. I can't tell you how badly I feel, and I'm not kidding.
You should.
Yes, sir.
Jim Preston again, and I apologize. I'm just a real estate lawyer. I did do some litigation, but just enough to be terrified by it. But really, the witnesses really do need to be sworn. And also, just from an idea, she says that she was told by the city manager. You would need to talk to the city manager and say, did you tell her? And then say, did Mrs. Kidd or anyone else tell you to tell her? You really have to establish facts like that. It's just a little step by step, and I'm sorry that our judicial system does take time like that, but you just have to chip away at little facts, and it's very logical, but there's reasons for it.
Point well taken. Point well taken. And I would guess that Judge Minor is about to make that same point to Mrs. Rutten and me.
Well, of course, I would agree with the gentleman, and I'm concerned about the time. And we also have what is, in my opinion, another issue that needs to be discussed, and that is, if I may, I'm not the chair.
You're doing well.
And that is the issue of whether or not this board collaborates with a board that is or will be convened to hear a very identical complaint arising out of the same factual situation. We need to treat that, I think.
I have that in my head already. Some people need to quit their day jobs at the rate this is going. Hey, Mr. Bloor? All right. Thank you, folks. This is for... Point well taken. Let's assume Party A told Party B, and Party B told Jennifer. Therefore, by algebra, Party A told Jennifer. Correct?
It could be construed that way.
Okay. In that case, since that might be the case, I would like to put number one aside. Let's take a look at number two.
Thank you.
Okay. Hold number one in abeyance.
Until we find out if A did tell B to tell Jennifer. Does that sound illogical and unfair?
No. My question is, when are we going to do that?
I have no idea. But the sooner we get 4 pages and 8 items down to something manageable, the 3 of us can put our heads together and come up with a fair process. I just don't know how the 3 of us in an open forum like this are ever going to get anywhere. We've been here 1 hour and 25 minutes and we've not gotten through number 1 yet. The OJ trial went faster. Momentito. Yes, ma'am. Thank you very much. And this gentleman in the back, too.
Okay. And me?
If I may?
Of course.
I would second your suggestion that we held number 1 in abeyance and proceed. My concern is the time and the other issue that we have to take up, I think.
My concern is that first we go back to what the first concern was, the vocabulary of the words, and I think, or the meaning of those 3 words. That maybe we should, the 3 of us, come up with a conclusion on what the meaning of those words are. We can go back to Nexus, Lexus, or the Black Book and do that ourselves without having to hold people in hostage over 3 words. And then move on to your concern, whether the two committees should be combined if they are identical complaints. And then move into this after we have the meaning of the words and we've decided the committees, whether or not they're going to convene together. Because if they're going to convene together, then those other committees have to be a part of this too.
Agreed, but I would not want us three to do something based upon the premise that the others might join us. I think the three of us need to say, we're in this together, we took on this job, and we're going to do it right, whether we do it alone or whether they combine them all. And Mr. Bloor, if I'm not mistaken, there's no requirement to combine.
That is correct. There is no requirement to combine. That's one of those things where the two boards have flexibility, but there's no requirement.
Those other three folks that are going to meet, Mr. Yucca, Miss Judge Williams, and they could say, to heck with you guys, when I'm meeting with you.
So is it our decision, Mr. Bloor, whether or not we want to combine the three of us? No.
Whoa, just one Mr. Bloor.
It's the two boards. Both boards would have to agree. If you want
Both?
to combine.
One of the parties does.
Yes, I know that. All right, now hold on, folks. We had this lady and the gentleman. I got her.
Oh, okay.
You're up, sweetheart. Look.
Yeah, God, I can't go blank now, no. It makes a difference if we know what was said from A to B to C. I strongly feel that. And, okay, come on, brain.
All right, take your time.
Take my time.
Sorry, we'll come back to you, ma'am, I promise.
I'm sorry.
Gentlemen,
I may have missed something, but my understanding from earlier discussions and when you mentioned prima facie evidence was that you're to look at the 8 allegations, decide if they violate city ordinance before you actually start getting witnesses and finding out what happened, coming up with definitions. You just look at it as it's written, and correct me if I'm wrong, but that's what I thought the first step was.
Yes, Mr. Chairman, if I may, in view of the fact that a lot of time is running kind of short, I'd like to help or offer a suggestion as to how you might go about this. We talked earlier that under the city code, the first thing to do is to determine whether there are acts alleged that would constitute a violation of the ordinance. So, using number 1 as an example, the complaint says that ethics were violated in all of the following ways under City Code 2.78.50, paragraph J. And the first one is signs prohibiting posters not allowed in chambers. So, for the purpose of this first task that you board members have to do, just assume that this kid is completely responsible. Doesn't matter how it happened. Just suppose that she's responsible for that because that's what the allegation is. So, if this kid is responsible for posting signs that said that, the question is, does that violate paragraph J of the code? And I think that is the first question that you have to answer before you get into testimony about who did what or how it happened or anything else. So if I may offer that suggestion to you. And I think you need to probably do that with each of the 8 allegations.
I think that's an intelligent and efficient way. Wish I had thought of it. The lady in the back.
I have in the since I've written that complaint, I have read the city code backwards and forwards, as well as every minutes for all the meetings going back 10 years. I would be glad to amend my complaint to boil it down to less than 8 points, if that would make this easier. Because I do know that a few of my points actually are a little muddy than it was. But I think at this point I have a much better handle on it, and I could get it down to 4 points, which would make your life easier. So I could amend my complaint.
Thank you. You'll understand if I defer to that one, on that one, because that's something.
If it would, I could just boil it down to 4 out of the 8, because that would make more
Ladies and
sense.
gentlemen, hold that. Your comment and offer is well received by me, but I am not in that position. I will have to ask Mr. Bloor, who heard your offer, to respond accordingly.
Yes, it's up to the board. You can accept the offer or not. Again, this is your show. You decide what procedure you want, and if you want to accept the amended complaint, that's your call.
Mr. Chairman, I move that we allow the complainant to amend her complaint and that we request that she file an amended complaint within a certain period of time.
I'll have it in 12 hours.
We're fine, Mrs. Smith, we're fine. I'll repeat my commitment to you. I will stay with this position until it's done. And it'll be done fairly, openly, and honestly. I give you that pledge. I'm in no rush to do this.
Thank you.
You're welcome. I owe that to you. I owe that to Mrs. Kidd. Your turn. You heard what the judge was suggesting.
Well, I heard what Mrs. Smith was suggesting. I guess I missed the answer.
Can't hear you.
Judge?
I move to allow Mrs. Smith to amend her complaint within a certain period of time. I heard her say that she could do that within 12 hours. I'm not sure that we need it that quickly, but, soon would be.
I would second that.
Mr. Wilson, good morning, sir.
Good morning again. Judge, I'm going to ask for a mistrial. We said earlier that, or the committee said earlier, that you were not going to be taking advice from Mr. Bloor, and in fact you are taking advice from Mr. Bloor. Mr. Bloor, as city attorney, represents Ms. Kidd as a city employee, and I'm seeing a little bit of ethical dilemma here.
No, that's not true. I do not represent Ms. Kidd. I represent the city. I do not represent the individual city council members. You are incorrect.
Mr. Bloor.
You would agree your advice?
Mr. Wilson.
Thank you.
No, you're welcome, sir. Mr. Wilson, Mr. Bloor. With your permission, and Mr. Wilson, with your permission. The one thing, if I'm going to serve as a volunteer on this committee, that all of us will incorporate into every word we say is respect, whether we disagree or not. I want us all to be totally respectful to our fellow citizens. You stepped out for a little while. While you were gone, I made the statement to everyone here that I, as the chairman, would defer to Mr. Bloor on all legal interpretations, explanations. I think that is our decision to make. And I made that statement a little while ago. I believe you had to leave at the time. So please do not say something to Mr. Bloor that might be inaccurate. I said, as the volunteer chairman of this committee, that as long as we're together, I would defer to Mr. Bloor for explanations, advice, interpretations, and readings. All right, sir? Now, you may disagree with my approach, which is perfectly fine. I understand that. But I wanted you to know that this didn't come from Mr. Bloor. this came from Frank Prince Jr.
I'm only suggesting there's an appearance of bias.
I understand, sir, and that's noted. That is noted, sir. I guess my response to you, Mr. Wilson, is this is a city endeavor. Mr. Bloor is currently the city attorney. If folks feel that the city has to go and hire an independent counsel to sit there, that's their decision and their right to say so. He is our city attorney, and as long as I am the volunteer chairman, unless the judge and Mrs. Rutten stop me, I will turn to Mr. Bloor for his comments. All right, sir? But I will ask all of us to be respectful, no matter how much you disagree with the job I'm doing, and I appreciate that. I'm not running for office. Yes, ma'am?
I remember the second half. I do also have concerns about biasness. You know, I don't know the gentleman, but I have a concern. The other thing is when we first started, and with all due respect, everybody, Mr. Prince, you said, it don't matter how long it takes, 1 day or 2 weeks. And then all of a sudden, okay, let's streamline this. I know, and sometimes that can be helpful, but the people have been ignored and suppressed so much. That's why we did by signs, because our time was being taken away from us to speak our truth. And I want something very honest, but I want it really thorough. Please don't speed it through. You know, don't whittle it down to something. Do the homework, ask the people that need to be asked so we can get the real meaning of what happened, and please don't shut out our voices. Thank you.
Thank you. You're most welcome. Yes, ma'am.
I would like to concur with her as far as the same meaning. The signs, we have been bringing signs into the chambers for meetings and meetings and meetings. And then all of a sudden, one meeting, there's this note out there, no signs are allowed in the chambers. We kind of take that as, oh, they're trying to silence us. Another form of silencing the people that want to speak. So that's where I'm at. Just so you understand.
Point taken and understood.
Yeah.
Please understand, on this side of the podium, we have been asked, let's just take number one. Because number one to me is a simple question. Okay? If signs are not allowed, they're not allowed. If signs are allowed, they are allowed.
But it's not.
Okay, that's what I'm trying to say. I think we're muddying the water there. All we've been asked to do, the three of us on a volunteer basis, is to find out if someone said, get those signs out of here, was that a violation?
It's not in the code.
And if it's not a violation, then our part is done, and it's up to the citizens to come to the city council saying, we want signs at every meeting, put it in the code. You're asking us to take on a responsibility, ma'am, that we haven't been asked to do. We've been simply asked to say, if the signs were kicked out, was that wrong? Okay, simple question for the three of us to decide. No, it wasn't wrong, because it didn't violate anything. Move on. What's the next one? Yes, it was wrong, and we will hold that person responsible. Am I wrong or am I right in my analysis?
Pretty close.
Okay, that's not bad for a referee. Yes, ma'am.
If it's not in the code, then we didn't violate anything by having a sign.
Here is Mrs. Smith here. Oh, okay. Do either of you have any objection to Mr. Prince serving as chair?
No.
And let's see, does anyone have any objection to any member of this panel?
I'd just like to ask, I don't know if it's pertinent or not, but where you guys each independently stand on the fluoride issue, and how is that going to affect, or should it affect, the outcome of this?
May, I'm sorry, but thank you.
Yeah.
Is this procedure today, Mr. Bloor, is this a question and answer session?
No, it's not. This is a more like sorry.
That's all right, it's not you, it's me.
This is more like an organizational meeting. You're going to determine how you want to proceed with the meeting. I think it is a good idea that you go through the same questions that the city council would use for appearance fairness doctrine. Apart from that, you're not required to do or say anymore. But again, it's up to you on how you approach this.
Okay, thank you. I anticipated that question, okay, I really did. Let me respond this way. The word fluoride is irrelevant, in my opinion, to the three of us. The city council meeting that is in question here could have been about any subject: homelessness, crime, taxes. I don't expect the word fluoride to ever come up again. I think our panel has been impaneled and empowered to review the actions of the city council members. What the meeting was about is irrelevant to the three of us, and I believe it's irrelevant completely to these proceedings. If I'm wrong, I want Mr. Bloor to say, "Oh, Frank, you made a mistake." I think we're here to look at the actions of the council members in regards to the city code, the municipal code, the state law. What the meeting was about has no bearing, okay? And that would be my response. If I'm wrong, I'd like someone to say, "Stop, Frank, you're going the wrong avenue."
No, that is the correct attitude that we would like the board to adopt.
Thank you.
Mr. Chair, may I respond?
Oh, knock out.
To the question specifically, I was aware that there was a question regarding fluoride. I remember receiving a survey in the mail, I believe, and my wife and I looked at it, and we did not complete it, as to my recollection, and we did not turn it in. I have no opinion one way or the other on the fluoride issue.
Judge Minor, would you register an opinion on this? A lot of the proceedings that brought us here today are the result of city council meeting. A lot of those city council meetings are guided by the legal advice of Mr. Bloor. Mr. Bloor is a victim or a target of another ethics complaint. We're talking about the appearance of fairness and lack of bias. Should he be the one advising you on this if he's also himself under an ethics complaint?
Oh, please, I have a response, but it'll be the same, I bet.
Would you please identify yourself, sir?
Yes. I'm Leo Wilson. I'm publisher of the Protocol Monthly News Magazine.
Good morning. I don't know the answer to that. I think that's up to Mr. Bloor and whether he conceives that he has a conflict. If so, he should recuse himself and another attorney would be appointed, I would think. And I'm going to leave that up to Mr. Bloor. Does anybody else have anything to say?
I'm not first going to qualify Mr. Pritz's statement, and I am in complete agreement with him that this is an issue involving a complaint. It is not an issue involving fluoride. And opinions on fluoride I don't think have any relevance whatsoever in this room. We're here because of a complaint, and that's why we serve on the Ethics Committee. Mr. Bloor, I don't know if you want to use the word advise us. I think he's a guide, but in agreement with Judge Minor, if he chooses to step down because he feels it's a conflict of interest, then we hold up proceedings because we're going to have to wait for another attorney to be appointed. I look at him as a guide. I don't look at him, sorry, Mr. Bloor, as a as someone who's telling us what to do. He's here to guide through the process. And I think the three of us are capable and competent enough to know the difference between a guide and somebody telling us what to do.
Can I proceed with the question?
I was going to ask you to do so. Miss. Yes, ma'am. Hello.
Yeah, I just have one concern. I'm Deborah Wilson. I'm born and raised here.
Hi.
Hi. Nice to see you, Mr. Johnson. I'm not familiar with the lady on it, and I can't quite read her name because the glare is on the thing. But I'm a little concerned that she's known Cheryl Kidd, like all her life, and the families have kind of known her for such a long time. How can you truly be biased? Can you say something to that?
The families knew each other when we were young. I mean, young. 5, 6, 7 years old. Miss Kidd left Port Angeles for many years. I left Port Angeles for many years. In fact, I think she came back after I did. But I would say probably since 1965, we have never socialized other than at a seroptimus function. I know her because small town, lived here all my life, except for 10 years that I've gone. So socially, no, other than seroptimus is all.
I think that she is acquainted with the complainant, Mrs. Smith, or Ms. Smith, and it was the day that my name was revealed as being selected to be on this board that Ms. Smith contacted my daughter by email and suggested that they have coffee together. And from what my daughter has told me, she has not had that kind of a relationship with Ms. Smith before. And I did not, and I don't believe she had the meeting with Ms. Smith, and I don't make any more of it than that. And like I said, I report it out of an abundance of caution, and it will not affect the way that I decide this matter. And I see Mrs. Smith has her hand up. You don't need to say anything. If you wish, you may, of course.
It had nothing to do with this at all. It was completely an independent thing regarding a July 4th celebration that I'm trying to come up with, and I was meeting with her because it was suggested that I should meet with her, but it had nothing to do with this.
Okay, thank you. All right.
May I suggest, Mr. Glover and Judge, would you take a moment, and I know you have an agenda here that you would like all of us, the three of us especially, to hear to be efficient and professional. May I ask that you plow right through that, and then we'll go to step number 2. Is that acceptable?
All right.
Thank you.
I only have one more question. Can all of us decide this matter in a fair and impartial manner based upon the record in this proceeding? I can.
Undoubtedly, honestly, and with 100% confidence.
I certainly can.
That concludes those questions. Thank you.
Thank you. Okay. I can assure you the president is not nominating me for the Supreme Court. I want you to know that. And you can tell by the way I'm grab bagging this, all right? Please. The Senate would never approve me. In front of us, with your permission, Grant and Danetta, I would like to read for the three of us. I guess the best way to proceed is for the three of us in a public forum to take the complaint and go through it, publicly discuss it, and see where we stand before. My impression, if I'm wrong, please stop me. We're not making a decision at this moment. My mind is blank, absolutely blank in this regard. I would like to build up, with your permission and your permission, information to help us make a decision. I have an absolute blank slate in regards to this complaint?
I don't,
Judge Minor, you're up.
thank you. The next question to us is, well, I'm sorry, do either of the parties have any objection to any of the board members serving? I may have asked that. If I did, I apologize.
I don't have a problem with that as much as I think that was a good point that he made about Fleur being also having a complaint against him.
Oh, thank you.
I want to make sure that I made that point.
Thank you.
Yeah.
Mrs. Smith, did you understand the question?
Yes, I did. And
All right.
I have no complaints.
Thank you. And do any of us have a conflict of interest to disclose? I do not.
None whatsoever.
None.
Do any of you have any private information about the subject of this complaint? I do not.
None whatsoever.
None whatsoever.
Has anyone received any ex parte, that means outside of this room, communications about this complaint or matter? I have one. In just a moment I'll review.
The communications I've received, people are fascinated that I would actually volunteer. They're running for the hills saying I would never do this. I look at them, I'm saying it's my responsibility, my obligation, I volunteered, and I'm proud to do it. But all my friends think I'm nuts. But they're right.
In a good way.
Like they do, and I think that's a fair question. Matter of fact, just the other day at the gym, one of my very closest friends said to me, "Why are you doing this? You're crazy. I would never do that." I looked at that person and I said, we all have responsibility to do this, whether it's pleasant or unpleasant. And I truly feel that way, and I want to make my commitment to all of you that are seated here and those who are not, that I, Frank Prince Jr., will give you the most honest effort possible. I know Grant and Danetta will also, but that's a fair question.
Communication regarding the complaint, no. But clarity from the public when you, and I think we made this clear tonight, because a lot of the public feel this is an issue that has to do with fluoride. Don't look at it as an issue, as a complaint. So there's been a couple of times I've had to clarify that this is not to do with fluoride. As far as the complaint, no, I've had no communication.
I said that I had one matter to reveal, and this is something that I do in an abundance of caution, because I don't think that it was, well, I know it was not a communication, and I doubt that it was an effort to communicate. However, I have an adult daughter who is active in the community.
Good question. I've never met Mrs. Smith. If I have, I apologize, I don't remember. I've been in Port Angeles 42 years. I don't think I know Mrs. Smith. Mrs. Kidd, I probably have said hello to her 3 times in the last 5 years. I know she went to Port Angeles High School. I spent my entire career there. I'd say on a scale of 0 to 10, my relationship with Mrs. Kidd is a 0.1. So I would say, in the answer to the question, no. Completely devoid of a relationship with both ladies.
No, I do not know her. And that brings to mind that this is a quasi-judicial proceeding, which means that we will be determining the facts of the complaint and determining the outcome based upon those facts and the law that applies. And under the laws of the state of Washington, this hearing and everything we do must be fair, and it must have the appearance of fairness. And so your question went to that point, I believe, whether we know anyone involved, and that would go to the issue of an appearance of fairness. And in most proceedings such as this, there are some similar inquiries to yours that we should all answer. And I have taken a page out of another city council's procedure that deals with this, and I would like to read through the questions and then we can all deal with them so that we get started on the right foot. Is that okay?
That's fine. I'll answer.
Okay.
I do not know Mrs. Smith, other than Facebook once in a while seeing articles. I do know Cherie Kidd. This is a small town. I went to Port Angeles High School. She was a year ahead of me, I think, in high school. Her father and mother, and my father and mother were good friends. Socially, no. The only thing that we do socially is Soroctimus. She belongs to the new club Soroctimus. I belong to Jet Set, so we don't literally really socialize. But I do know her. I've known her all my life.
Directed to your specific question, I do not know Mrs. Smith. I know Ms. Kidd very, very briefly. I know who she is. I say hi. That's about all the relationship I had with her. I think that my son-in-law and I did business with her company or whatever business form it is when we rented a truck one time. And that's the extent of it. I'd like to go through the rest of the questions, if you don't mind, and they'll be directed to all of us. And this is necessary, as I mentioned, to ensure that this hearing is fair in both fact and appearance. Does anyone have any objection, specifically the parties? I know Ms. Kidd is here.